I'm Jennifer Archie. I'm worked with NYU Law and with Judith on a number of programs like this in the past, and it's just always a complete privilege to be in this room. And I'm a partner in the DC office at Latham & Watkins after I worked on the Hill for 4 years, and then I went to law school, and I've been at Latham my whole career, more than 30 years, before Al Gore invented the internet. So I wasn't doing cybercrime, but I switched into that as very large networks started to be attacked, and that's today I do a lot of regulatory investigations and crisis management and response. Thought we'd all say a little bit about how we got into cyber, and mine really was I had a major client, America Online, that I was just a litigator going to court, doing litigation with them, and spam and attacks on the world's largest email system became so prominent that it became almost my full-time practice for 4 years, and became more and more about criminal referrals, and as the J curve of attacks went, so did my career. So after that, that was really my mid-career pivot, if you will, to that, and since then I've obviously learned a lot about privacy and all the interrelated issues. I'm completely delighted to be next to Harriet Pearson, who's been a tremendous, woman in cyber law and leadership for many, many years. And please introduce yourself, Harriet, and then we'll go right to Melissa.
Thank you, Jennifer. Good morning, everybody. Nice to be here. I'm Harriet Pearson, currently, as of last August, the head of the cybersecurity division at the New York Department of Financial Services. And so delighted again to be here. How I got into cybersecurity is been in it for probably 20 years now. And before then, really I'm a lawyer. I have an engineering undergrad, worked as an engineer for a little bit, and was at IBM, and started in the IBM Public Policy Office. And when the commercial web was emerging in the mid-90s, was asked to work on privacy issues and other policy issues, and became ultimately, in the year 2000, the company's first chief privacy officer, and held that role for 12 years until I left. But as privacy is almost the flip side of cyber in many ways, started edging into cybersecurity when questions would arise, issues. And I'm on the career panel later, but one of the lessons here is always be open and say yes to opportunity and to hard questions. And so I got into cybersecurity, became a counselor, ultimately a risk manager, compliance person, lawyer, because I said yes to questions that kept being raised. And left IBM in 2012, and for 11 years was a partner, founded and led a law firm's cybersecurity practice, and then 6 months ago joined DFS, where I'm really privileged to be leading a team of very dedicated and great folks, and we're hiring more, but who are the stewards and have been hard at work at the department's first in the nation cybersecurity regulation, also known as Part 500. We'll be talking about that later. Thank you.
All right, good morning, everybody. I'm Melissa Hathaway, and I've been working in cybersecurity since the early 1990s. I was at Booz Allen Consulting at the time, and was asked to lead the information warfare net assessment for the Secretary of Defense, then Secretary Perry, in 1994. This is before cyber was sexy, and before we really had so many vulnerabilities and everything. I had a mid-career pivot in 2007. I was asked to join the administration for George W. Bush. I led the cybersecurity strategy for President Bush and put most of the programs in place in the United States government. I was asked to transition and work for President Obama. So I am technically purple when you come to Washington. That doesn't happen very often. And I had the opportunity to lead the programs for him and stabilize everything between the two presidents. When I left the administration, I went back to consulting. I do still a fair amount of work for governments in the US government. I advise corporations on digital risk management, and I advise boards, and I teach. Occasionally I teach here at NYU for Judy. I teach up at Harvard, and I have a mid-career women executive education program at Toronto Metropolitan University to give them the skills to get to the next level.
Thank you. Carolyn.
Hi, and hopefully you all can hear me. I'm Carolyn Welshans. I'm an Associate Director in the Division of Enforcement at the Securities and Exchange Commission. Before I get started, I have to give a disclaimer that I have to give every time I speak, and that's that I'm appearing here today in my capacity as an Associate Director, and the views I express today are my own and not necessarily those of the Commission, the Commissioners, or the Commission staff. Like my fellow panelists, I have been thinking about cybersecurity for most of my career. I've been at the SEC for over 16 years and have worked on cyber investigations pretty much the whole time. Started with people hacking into broker-dealer accounts and stealing money or placing unauthorized trades. I've worked on investigations where we've charged hackers, investigations where we've looked at company disclosures following cybersecurity incidents, as well as their internal controls. And I've also worked on many investigations following cybersecurity incidents where we did not charge any violations of the securities laws because we determined there wasn't a violation or a basis for a charge. So I think it's just an incredibly interesting area. This is a great conference, and I'm really excited to talk with my fellow panelists and hear their perspectives.
Thank you so much. So just a little set the stage. We're going to start with just a little bit about what's special about cyber. If everything, make sure everybody in the room and on the Zoom is kind of well grounded in what are the scope and regulatory authorities of the DFS and SEC here. We're going to look at the rules that were just announced in the last half of 2023. We're going to do a little deeper dive on governance and risk management, two big themes that you'll tease in the rule, and then everyone's favorite of incident reporting to the government. And we certainly want to take your questions at the end, so jot them down and save them. When we get to questions, you just want to be mindful that if you could direct them to the panel and folks can choose which ones they want to take, because it may or may not make sense for a regulator to speak up in a particular topic given the sensitivities of their job. So let's just get right into it with a bit of a round robin on why is cyber risk kind of relative to all the risks that financial institutions or public companies might experience? Why does it get targeted regulatory attention now? Is it different from other risks? And if so, how? What's the same about it? And but just maybe do a round robin on that. And I'll start with Carolyn. You're to my right, so we'll start with you.
Thank you. I think it's a really interesting question, and I've been thinking about it. I mean, I think for me, one thing it comes back to is that it really does impact everybody. It impacts every company. It impacts all of us as individuals. There are a lot of very dedicated cyber criminals out there trying to get information, trying to get people's personally identifiable information, trying to get very sensitive data that companies have, including their intellectual property. It just really runs the gamut. And so I think the fact that it impacts people, it impacts their wallets, it's something that we've all had to learn to try to deal with, and yet it keeps getting more and more sophisticated. I think that's something that does therefore create a situation where everybody has to pay attention. And I think we're going to dive into the details today about how they pay attention, why they pay attention, what they have to do as a result. It can be very specific and different, but it is a problem that impacts everybody across the globe, and it's not something that is going away. It's just getting stronger.
Thank you so much, Harriet. What would you say?
I think that's really well said. And there are many actions that individual organizations can take to protect themselves, and that's a theme that I think I'm going to keep coming back to. And it is an interesting question. Why is there targeted regulatory attention right now in 2024? I would say, from the Department of Financial Services, that targeted regulatory attention came multiple years ago in 2017 when the regulation Part 500 was first finalized after a few years of consultation and work. That indicates that it's been there, it's been a focus, but I think more and more there's a more national, well, actually international focus on it, because you need the whole of government of approach. You really do need to exercise all the capabilities, because for the last 25 years there have been a number of private public partnerships, institutions being built, standards being developed. There's a lot that has been done, but more needs to be done. So I'm agreeing with what Carolyn just said, but just saying it a little bit differently. It is the challenge of an era, and I would say it's very similar to other risks. I mean, there are a number of risks that face organizations, of course, and that has to be managed. And risk management as a discipline is something that's really interesting and important. And this is cyber and digital risk is one of those areas, but it is pervasive, it's very horizontal, and it's new.
Melissa.
I agree with all of that, but I want to set a context of, I think it's really important. So the internet is 54 years old, October 29th, 1969. And so we've had an evolution of the technology and how we connect our critical services, our companies, et cetera. And it wasn't until really 1985 that we released the .com domain. And so .com was born in 1985, and it only released 15% of the address space because we didn't really actually think this was going to take off as e-commerce and along those lines. The internet that you all work with today, I would argue, was born in 1990 with the World Wide Web that allowed you to click, connect, and search information all around the world. And you didn't have to know what the IP address was. You didn't have to be a technologist anymore. So it made it much more consumable, and therefore it increased the adoption rate of the technologies of connecting our critical services and infrastructures. And that was the year 2000 where we started to say, wow, we've connected a lot of things to the internet now, and it's vulnerable. And so if you look at, between 2000 to today, we've connected a lot of information communications technologies to the internet and from our businesses, our critical infrastructures, et cetera, to get to that automation, that interconnectedness. And we've become completely reliant. But the underlying fabric is actually pretty vulnerable, which is why the threats have increased pretty significantly in the last 25 years. Where a simple criminal or a teenager can take down a critical company, a critical infrastructure, a critical business. And it's not just the United States, it's every country around the world, because our companies and, quite honestly, our governments have underinvested in the resilience of these critical services and infrastructures. And so now we've had to have regulatory intervention in order to demand the resilience curve to be built back in, which is going to take 10 to 15 more years.
Thank you, Melissa. And I think, you brought up, the individual lone hacker that can have an asymmetric impact, but it's also highly weaponized, right? Like quite literally, but also, nation state attackers and organized crime, gangs. And so as the threat landscape has evolved, so much, I think, we're focusing on two particular regulators, for the next hour or so. And they are looking after public companies, where you have investors as a huge stakeholder, and also an expectation of a certain level of governance and risk management embedded in those, in that status of being, having the privilege to go to the public markets, capital markets, and the expectations on those entities. And then financial services, which is really critical infrastructure, right? We could be here talking about defense or telecom or utilities, lots of different critical infrastructure. But I think it's important and not a coincidence that these two very specific regulations that have come out, and with fine-tuning really of long existing principles and requirements, are focused on public companies and financial services. There's two really critical and important sectors. So, with that, let me just ask you, Harriet, legally, super basic and summary, what's the scope and authority of the Department of Financial Services in New York, and why are you so, have such an out, and we're not here in Iowa, like why is, New York so, so important?
I don't want to pick on any other states.
No, I just did, I apologize.
We are here in New York, and I'm proud to be a native New Yorker, and it is the financial services center of the United States, if not the world. And so just as a baseline set here for everybody, particularly our students who are tuning in, the Department of Financial Services was born out of the unification of the banking agency, or the agency that regulated banking in New York, the oldest banking state agency in the country, and the insurance regulator, fused together in, I think, 2011. So it's a relatively youthful agency as a unified regulator, and it has a very broad scope, overseeing a core of over 3,000 financial services institutions, approximately, I think, I'm going to look down, 1,300 banking institutions, different types of bank, credit unions, that sort of entities, and then about 1,900 insurance entities, and then an additional number of smaller insurance producers, agents, brokers, that sort of thing. So it's a pretty diverse set of entities in the financial services space, both insurance and banking. And the assets managed are over $9.5 trillion, a lot of activities. And the authorities are fairly broad. And with respect, I know you're going to ask me about cybersecurity regulatory authority. It comes from a number of statutes, and I won't quote the law, but it's all out there on the web, and legal research. Great project, if anybody's interested to look at it, is there are multiple sections of the New York Financial Services Law, the New York Banking Law, and the New York Insurance Law. And what we know as Part 500, or the cybersecurity regulation, is promulgated under all of those authorities because DFS is what's known as a prudential regulator, which is overseeing the safety and soundness of the sector with fairly broad authorities. And Part 500, or the cybersecurity regulation, was promulgated in 2017 to take what had been guidance and really put into regulatory language the more or less industry standards that had been evolving at that time. And the amendments that were recently finalized November 1 of 2023 were again updating the regulation to reflect more of what the department, or the DFS, had learned over the last several years was now industry standard in terms of protective actions companies are taking to mitigate cybersecurity risk. So that's a very broad brush.
Yeah. Carolyn, we wouldn't think of the SEC as a cybersecurity regulator, so maybe at the risk of asking you an overly broad, question, can you kind of just, frame that for us about maybe what you were seeing in enforcement and how, the need has kind of arisen to have what we're about to get into, which is a very articulated approach to disclosure around cybersecurity risk.
Sure. So I start with the SEC's mission, which is three parts. It's to protect investors, to maintain fair, orderly, and efficient markets, and to facilitate capital formation. And cybersecurity risks and events implicates all three of those parts of the mission and can have a really negative impact on each part. Since we're here today to mostly talk about public companies, I'll focus on the fact that first and foremost, the SEC is a disclosure agency. We're very focused on what investors are being told, and do they have the information they need to make informed decisions. So recognizing that cybersecurity incidents are going to happen. A company can have incredible controls, but that doesn't mean they are invulnerable from a cybersecurity incident. And so, I think we really are looking at what have companies done to try to do the best they can to prevent against cybersecurity incidents. And when, the pretty much inevitable happens that they suffer one, what do they do as a result? What are they telling investors? How are they investigating those cybersecurity incidents? What is happening internally at the company? How prepared are they? So those are things that I think we're all going to talk about today, and all of those feed back into that central tenet of disclosure to investors when and if there is a material cybersecurity incident. Just like we're focused on things outside of cybersecurity that might be really important to investors. There are a whole host of things, and cybersecurity may be one of them.
And I know both agencies have brought some actions, have had a lot of report. They, as everyone points out, this isn't a terribly new risk in its own way. But at this moment in time, is there anything you'd highlight from, general observations about learnings from enforcement, cases that were brought or cases that weren't brought, that have sort of helped inform and set the stage for the rules that came out last summer? Harriet, you go.
I will just say that it's all about the data. You go where the data leads you. So and DFS is got a pretty robust online cyber resource center. I would recommend it. There's a lot of FAQs. There are all the enforcement, the consent orders as a result of the enforcement actions taken that have to do with cybersecurity and content on the new regulation, et cetera. And over the last several years, 5 or so years of experience with implementation of Part 500, the original Part 500, the data showed that as companies reported, there's a requirement to report incidents. We used to call them events, now we call them incidents, to the DFS. Hundreds of incidents, hundreds and hundreds over the years. And as the department looked at them, there were patterns emerging. Now, I should say that many pieces of information get shared with the department as a prudential regulator, and the department operates under strong confidentiality requirements. So that is important as a consideration here in terms of a regulator like the department has insights derived from that kind of pretty significant exposure to the operations of entities. And so the department learned and takes that data and attempts to apply that insight to requirements and to practices. And so the learnings here is much more from what you don't see in terms of enforcement action. It's, many of the actions, many of the incidents, the breaches that occurred could have been prevented had some significant, what I would say are industry standard controls, multi-factor authentication, having good governance practices where there is scrutiny over the security program, those sorts of things could have been prevented and were not. And so it became an insight that said, we really need to, step it up in terms of mandating those kinds of steps. And so that's one piece of learning. Yeah. And I think the enforcement actions that resulted are all posted, and the actions there are pretty clear in terms of, there were clear misses in those, and sort of useful to read about them, I think.
And again, coming back, Carolyn, to the mission of the SEC as being one principally around disclosure, how did the learnings of, what you learned, obviously as an agency you have lots of data endpoints as people, make their public filings or are in dialogue or they're in, enforcement. But can you just, speak a little bit to how the agency's experience with, just events, their consequences, the disclosure, kind of, rolled into, the insights that we're going to, cover that we see in the rule?
Sure. So I think, one piece of learning I've seen, over my career at the SEC is that there are a number of companies that are getting it right. They when they have an incident, they, are able to go back and recreate what happened. They've got, pretty healthy forensic evidence. They've got escalation controls. And we, have seen disclosures of incidents. And then, obviously we take a look at those. And those may be ones that we investigate, but then end up not bringing a case because what the company said lines up with what happened. So that's one piece of learning, and I think one thing to keep in mind. But I think there are definitely companies that are not getting it right, and I think it's important to try to have a level playing field and consistency for investors when it comes to disclosures and the expectations of what's going to happen. And so I think one theme you'll hear from me as part of this discussion is that we have seen companies, when there is a cybersecurity incident, there's a lot of knowledge on one side of the house, on the tech side of the house. And understandably, these are people who are dedicated to figuring out what happened and protecting the company's system. And that knowledge, for different reasons, does not make it over to the side that's responsible for disclosures. And so there's a disconnect between what is said to the public about an event, or even that there's been an event, versus what knowledge is actually within the company. And so that's one thing. And then the other kind of major theme and place where we've seen issues is that companies that have had a material major cybersecurity incident that they know about will nevertheless continue to describe their cybersecurity risks to the public in terms of hypotheticals. We may experience this. These things could happen, when in fact they have. And so that presents a disconnect for investors between reality versus what they're being told. So those are some of the areas of focus based on what we've seen.
Let's dive right into. Before we do that, let me ask Melissa. I think that building on what Carolyn said, the rule that came out from the SEC last July should be very familiar to people who advise public companies or who are on boards of public companies all the time at some level, right? These principles have been out there for a long time, and I wonder if I could just impose on you to be a bit of a narrator of a bit of the history of how the background of the SEC rule and why that disconnect between the hypothetical nature and the cookie cutter nature of some of the disclosures versus what other political forces were concerned about.
Yeah, so I think it's important, again, that context matters, and this rule didn't occur just overnight. This rule has been percolating since 2010. And in the 2010 timeframe, there was a series of breaches against really the multi-factor authentication, RSA, DigiNotar, like almost all of the technologies that were being used for multi-factor authentication to come in from a VPN had all of the technologies were compromised in the same year. And that presented big risk to financial institutions in particular, and then other risks to defense industrial base and all of what we would consider economic and national security industries were at risk. And that was also during the same time that there was a lot more conversation about what is the aggregate risk to the economy if these certain companies were to be breached or organizations. And in 2011, in the May timeframe, Senator Rockefeller at the time and other key prominent members who are still senators today sent a letter to the SEC and said, we need to have better disclosure of these risks and what's happening, because we believe in aggregate this is an economic security problem as well as a national security problem. October of 2011 was the first set of guidance coming out of the SEC, which evolved again and again. And I think that for the Biden administration, there were a number of incidents that occurred as they were assuming office. Was the SolarWinds incident. SolarWinds was a network management monitoring software that was core to the Fortune 500. 400 of the Fortune 500 used it, as well as across the United States government and others. And they were breached by the Russians. And then just a few months later was the incident with Colonial Pipeline, which was the intersection of information technology and operational technology that literally caused an economic crisis in less than 5 days in the United States. And we live here on the East Coast. We were particularly affected on the East Coast and was acutely aware for those of you who are a little bit younger than I am. I mean, I grew up I had the 1970s gas lines, and so this was like sort of a nightmare, Groundhog Day. I think to build on what Carolyn said, that part of the problem that we have, and that is still, it's an opportunity for learning and communication, is there needs to really be a translation of the technology risk into operational terms. And our technologists and our IT professionals are not very good at being able to describe what the risk is in the technology and what it means to business operations. And what is the cost per minute, per hour, per day of being offline when I need it to be online? And our executives that are running these companies say, oh, that's IT. Well, no, you're running a digital business. and therefore it has to be aggregated up to enterprise risk, and the executives, the officers of the company, need to communicate those risks in the operational, financial, legal, reputational terms. And I think that's really the spirit behind this evolution of the last 12, 13 years of this is an economic and national security problem, and we cannot quantify it at terms that are necessary, and therefore we must have disclosure. And we need to have responsible technical controls, administrative controls, and legal controls, just like we had after Sarbanes-Oxley. I mean, this is no different than the Enron moment. It just took 13, 14 years to get there.
Thank you, Melissa. So let's dive in now. I will, at Carolyn's request, I will kind of unpack the new rules for the group that were announced last July by the SEC, and I hope to do it in about 5 minutes. So don't worry. We know that you all know how to read, and you can go out and learn more about it. But basically, on July 26th, all these behind the scenes and the different directives and guidance culminated in the adoption of the new rules to enhance and standardize disclosures, focusing on risk management, strategy, governance, and incidents by public companies that are subject to the reporting requirements of the Exchange Act of 1934. So the first big area was disclosure of material cybersecurity incidents. So domestic registrants, and these apply to whether you're a foreign private issuer or a domestic registrant, they're pretty similar, but they have their own regulatory regimes and their own filing and forms. So the disclosures filed on Form 8K, so it's different than just putting a statement into the public. This is an actual filing on a Form 8K, and the trigger is within 4 business days of determining that a cybersecurity incident is material. And for foreign private issuers, it's on Form 6K promptly after the incident is disclosed or otherwise publicized, or should or is required to be disclosed. So that's the 8K, 6K chapter. And then there's also annual disclosures that are filed on Form 10Ks. We're in the middle of the annual report seasons, just kicking off right now, and it's very interesting. We have our library combing, as does everybody else. I think there's something in the journal, today to see like how are public companies going to be responding to these new disclosures around risk management strategy and governance. So to unpack the new Form 8K a bit, the first question is, what's a reportable incident, right? What is a cybersecurity incident for these things? And there's a number of little interesting things about that. A cybersecurity incident is an unauthorized occurrence or a series of related unauthorized occurrences. So you could have a pattern of something happened to you a year ago, but then a control failed again, a similar control failed again and again and again. Lots of discussion about what makes something a pattern, but definitely the SEC want to say it's not just one occurrence. It could be a series of related unauthorized occurrences on or conducted through the registrant's information systems that jeopardizes the confidentiality, integrity, or availability of the systems or any information residing on that. So if you think about what that applies to, that's going to impact, that's going to cover incidents that impact availability of data, right? It's a security breach if something's encrypted and you can't get to it. The mere unavailability is a security breach. So that brings in your operational incidents like ransomware. It's going to cover third-party incidents because of the definition of it's something that's on or conducted through the systems that they use. So that's vendors, service providers, supply chain, and partners. It's about electronic information resources and systems. So it's not about hard copy. We had a warehouse and someone decided to take 800 boxes. I don't know of this, but that's not what this rule is about. And again, smaller but continuous attacks related in time and form there. So that's the first area of inquiry is it a cyber incident? The next one is the incident material. And, one of the things you could note is material is a word in Webster's that shows up in the law over and over and over again, but it means different things in different legal contexts. So what might be material if you're a safety and soundness financial services regulator may not be what's material under longstanding SEC jurisprudence. So I like to always say this is a very cross-functional area where people really need to link up and make sure you're not applying your own subjective, God forbid, or the wrong discipline's definition of material. So importantly for the SEC, the traditional materiality standard is unchanged, right? It's a substantial likelihood a reasonable shareholder would consider it important to an investment decision, or that it would significantly alter the total mix of information available. You must consider qualitative factors alongside quantitative factors in assessing materiality, and doubts should be resolved in favor of those the statute is designed to protect the investors. So the commentary gives us some factors on materiality. It might impact financial condition and results of operations. It might be harm to reputation, customer or vendor relationships, or competitiveness. So one of the things we'll ask people is like, what's in your sales pipeline? Is there something really key? Is this going to derail you? You were in a hot RFP and you already this would have been a material type of a win of business, and now this incident has delayed your expectation of a win of business or just your overall competitiveness. And thirdly, just the possibility of litigation, regulatory investigations, or actions really anywhere in the world, because you're looking at it from an investor's standpoint. So there's some very good examples of potentially material incidents in the proposing release, and when we analyze these, we do that. And then the third thing to unpack there is just, is the determination timely? You need to do this without reasonable delay. If you can't determine the full extent, or you still need to investigate, that should not delay a materiality determination. So you're standing up a process to consider disclosure right away, and you can't just say, oh, I'm going to wait and see how this thing turns out. You need to, for incidents that impact key systems or large quantities of particularly important data, that you may then know enough to make the determination of materiality, and you don't want to mess with your internal procedures and policies that you already had in place beforehand to manipulate them to decide that you could, like, okay, here's how or why we're going to delay materiality here. There's a flag in the release that would be unreasonable delay. They say disclosure becoming due less than a week after discovery should be uncommon, because it may take time. And I think there's a lot of criticism in the enforcement about delay. That's a big theme in what you see, but also the interest in just not being second guessed on this and coming out early. So I think these are not that easy to apply in a situation. So the continuing, you file the Form 8K within 4 business days. You're going to describe the material aspects of the nature, scope, and timing. Describe the material impact or reasonably likely material impact on the registrant, and you see a lot, if you monitor these in practice, of people say, well, we don't have that yet, but we still want to disclose. There's a possibility for delay on a very narrow national security type basis if you go through a process we probably won't cover today, and really important, you have to keep it updated and amend the Form 8K. So you can see a lot of diversity in the 8K practice, where you see some people have kind of waited, maybe in the nature of their incident, company waited to make one major announcement and they may not have to do much updating. You see others that are like, I'm going to plant the flag and make people aware we're dealing with something, and then they're going to update maybe weekly as new information comes back. And then the second big topic is what's going to go into the annual report. And one big focus is risk management and strategy, where the company needs to now describe their processes for assessing, identifying, and managing material risk. There's a lot of good guidance in the reg, and we're going to dive into this a little bit later, so I won't Dwella, and the second one is on governance, where you're going to describe how does the board oversee risks from cybersecurity threats. You're going to identify board committee or subcommittee responsible for the risks, describe the processes by which the board or the committee is informed about cybersecurity risks, describe management's role in assessing and managing the registrant's material risks from cyber threats, and some specific disclosures around that. So that's the SEC's approach, is tell us if you're dealing with something material, tell it on a particular form and a particular timing now, the 4 days, and make sure that you have injected disclosure considerations into your incident response from the beginning, and again, the annual reports needing to provide more context. So, Harriet, how would you sort of lay out for everybody the key changes and your kind of phased approach to coming into line with new DFS regs?
You did such a good job. You could almost keep going.
Yeah.
And do DFS as well. But I'll take a spin through and just give an outline. Just again, baseline, level set for folks. So as I mentioned, the Department of Financial Services cybersecurity regulation was recently amended and was published November 1 of 2023. First thing to know is that the structure, the approach, the bulk of the regulation was not changed. And so I'll explain the approach and then talk about what's different, a little bit what's different now. So the approach is risk-based, and people use that term, and it's a loose term, but let me explain what we mean by that. The requirement of the regulation for regulated entities, which means pretty much any institution or entity or even individual who has a license from DFS, there are some exceptions, must put in place a risk-based cybersecurity program that has certain elements in it. The bulk of the requirements of Part 500 have to do with having the required set of governance processes, which means you should have policies, you should have accountability. What's changed now is that they're spelling out in the amended regulation, you must have procedures and you must implement procedures, which is sort of what it makes sense, but we spelled it out, right? And so it's a risk-based program that defers to the company, to the entity, to assess its own risk. So there's a requirement to conduct a risk assessment and use the results of a risk assessment to then put in place the controls necessary to achieve risk management in this area. That's the structure. So the amendment that was just finalized did a couple of things. One is it delineated 3 different types of regulated entities. We tailored the regulation a bit more to the size and level of risk to entities. So there's a new categorization, Class A companies. And we're not planning to go to Z, but it's just Class A. And those are very large organizations. And there are details about the levels, but basically it's a $1 billion organization or a large workforce type organization. And that type of entity is expected to comply with all of the requirements in the regulation that are spelled out. And they have the ability, they also have the risk profile to take on more of these controls. At the other side of the spectrum are either exempt or limited exempt entities that are smaller, and they're supposed to be, either because of smaller, because of certain type of niche businesses, kind of exempt, or only have to do a portion of the regulatory requirements. And that category really is intending to exempt, when you're talking about size of entity, 500.19A is small, like very small, less than $7.5 million in revenue, I think less than 20 employees, that sort of thing. So small organizations. Everyone else falls into the middle, I'll call them standard for purposes of our discussion, and that's the core of the requirements apply to those entities. So that's one thing that's changed. There's a phased-in compliance. So the regulation was published November, and there are 2 years to implement all of the requirements. So not everything needs to happen right on November 1, 2023. So some elements of it have already gone into effect. For example, as of last December, the incident reporting requirements, because those take less time to amend processes inside organizations. They're not technical. They're just, okay, to sort of change how we work together inside an organization to inform. Those have already taken effect. And on incident reporting, or reporting, what DFS has had in place since 2017 is an annual reporting requirement. And it used to have to be signed by the board chair and the CEO, and the adjustment has been, so now it's the CEO or the head of the business and the CISO, Chief Information Security Officer, or equivalent, or if there isn't a CISO and it's a smaller entity, the head of whoever's responsible. It might be the same person, but for larger standard size organizations, probably 2 different individuals need to sign an annual certification either of material compliance, there's the word material, or an acknowledgement of non-compliance. And this change, that's a change, was in response to industry saying, it used to be just one option, which is file your certification of compliance. And the questions were raised that, what do we do if we had an issue? We had an issue over the year. Nobody wants to file an inaccurate certification, clearly. So the department has created a couple of options. The submissions happen through the website. The website's been updated, so the instructions are now how to do it, and those are due, same as always, by April 15th for the year prior. So that's one change that happened in terms of the annual process of saying, DFS, this entity is here, or a licensee or an entity that's registered under DFS, and we are reporting our status on security. Another change is in reporting incidents. There, the requirement has been in place to report an incident to the department within 72 hours of determining that an event, or now we call an incident, has occurred, and those continue. There was an additional requirement added about ransomware. So in addition to the first prong, which is if your entity had to notify another government agency or body or self-regulatory agency about an incident, you need to tell the department, whether or not it involves a New York State resident's PII or personal information. It's if the entity was reporting to another government or agency, you need to tell the department. That was one, that's an existing prong. The second is a reasonable likelihood of materially harming any material part of the normal operation of the covered entity. So only lawyers love those phrases, but it's been there since 2017. And then added to it is the deployment of ransomware within a material part of information systems is now part of it. And it's really to recognize that the scourge of ransomware is something so notable and so important to try to mitigate that it helps the regulatory process, the prudential responsibility of the department to have visibility to it. In addition, again, ransomware, there's a new requirement, and as far as I know, the Department of Financial Services is the only agency that has implemented this requirement now in the world, is to report quickly within 24 hours of making an extortion payment. Should the organization be the unfortunate victim of a ransom extortion, cyber extortion situation, is to notify the department. And within 30 days of that, provide a follow-up report that outlines the considerations the company thought about as it made a decision to pay the ransom payment. Now, we all level set. It is not illegal to pay a ransom payment in this context or other contexts, I don't believe. Unless the payment is something that falls afoul of sanctions rules. And so there is that, and you have to check and make sure that you take some due diligence to understand that you're not sending a payment to known threat actors who are listed by the US government on sanctions lists. But apart from that, it's not illegal, though it is highly frowned upon. The Department of Financial Services does not encourage ransom payments, neither does the FBI, neither do other law enforcement institutions, agencies. However, if the company decides to pay that, that they need to explain their considerations, the thought process. And my colleague, one of my colleagues at the department uses the term speed bump. And so it's really an intention of creating a speed bump on the way to paying that payment is to ask the organization to document and think through and consult internally and that sort of thing. So that's noteworthy as well. And I think because of time, I'm not going to go longer unless, but there's on our website, on the Cyber Resource Center, are timelines with all the effective dates laid out. We have been committed to educating and outreach. So we have literally had thousands of attendees since November at webinars that my colleagues and I have been hosting and presenting on the content. So all of this content is there and ready to help anybody who's interested in becoming more familiar with the details, and any follow-up questions on that can be sent to the department. There's a dedicated email address, so we are really committed to getting the word out about the changes made, which fundamentally we're all about adding some more color and context and specificity around what does a company need to have in place in order to have an industry standard, consistent with industry practice now, risk management program. It has to have governance. There's some content there about what's expected of boards, a specific, very high level, but nonetheless specified. Boards need to be asking questions. They have to be aware enough about the issues. They have to satisfy themselves that appropriate resources are being devoted to the security program. There's another example of what's changed. So I'll leave it at that due to time, but happy to answer anything.
We have the exciting development of a CLE script being timely at this time. So this panel has been approved for 1.5 New York State CLE credits in the category of cybersecurity-general. The credits transitional and non-transitional, suitable for both experienced and newly admitted attorneys. For those of you in person, please remember to sign both in and out at check-in in order to get your credit. For those of you joining virtually, I'm going to be announcing the CLE code later. I can announce the CLE code now? Yes? I will be announcing the CLE code as CCS, as in Sam, 5673. One more time, CCS 5673. Great. Melissa, we're going to turn and talk about governance a little bit. We hear about it, so much, and I know you spend so much time with boards and directly in. Just give us a couple minutes on why is governance so critical and therefore, of course, such a regulatory focus of mandates.
Well, I think it's getting to the safety and soundness of the market and the institution, and I think about it as really the general responsibility of the business continuity of whatever the entity is that you're running, and so the board needs to be able to ask good questions of. Does management understand the threats to their digital business? Like just basic table stakes. Do they understand what their digital dependencies are? And there'll be there's 4 areas that I think go into the specifics that the Department of Homeland Security is are you patching your software and hardware on a regular cadence? That's hard to do. It's high OpEx intensive. I think you also have to understand how much technology debt you have in your infrastructure, because the unsupported hardware and software is 100% vulnerable 100% of the time. So I can't defend my business anymore. I think the next area is they want to know, have you instrumented your company to understand when there's suspicious or anomalous behavior in the infrastructure? And if you haven't, then again, you don't know if you've got a problem until probably it's too late. The third is are you ready for a business disruption? And I could argue that there are some companies who are well prepared, and I could argue the majority are not, because their business continuity disaster recovery plans are altruistic, they're not realistic. And we have to close the gap between altruism and realism on what it takes if you had a ransomware event or if you had a significant incident, and then preparing for that worst day. And so, I actually a lot of companies really have been, over the last 20 some odd years, have been, I want perimeter defense, I'm going to instrument these things. And I start with the question, let's start with, tomorrow is your worst day of your life. How quickly could you recover that business? And that then gets to good governance. And you start to walk it backwards and forwards of what are the real risks to my business? How quickly could I recover? Because it's all about business continuity. To deliver that sound, an operationally resilient capability, product to market, service to market. And I think at this point, when you start to look at the amount of healthcare institutions that are being ransomed, that's citizen safety. I have water utilities being brought offline. That's citizen safety. I have school systems that are being knocked offline all over this country, all over the world, but in this country. That becomes also a citizen safety, a real kind of chaos that's seeding problems in the country. Then if you look at oil and gas, manufacturing, rail, all of the other things that are happening, those are all going to impact our economy, and they all actually have national security implications. So we have to get to that governance of the digital risk to our digital businesses, and that requires everybody to be versed in and be able to speak that language. And it shouldn't be that hard. And I don't want to be, like some of our companies, they talk about these, it's a bear, it's a panda, it's a cobra, it's a whatever. And that's ridiculous. We've got a bad actor that has just knocked us offline. I'm not sure if I even care what that, if it's a bear, a panda, or a cobra, what country it's affiliated with. The fact is that I don't have water running to my constituents. I don't have a school system that I can operate and teach my kids. I don't have a hospital that I can reliably go to right now. That is a national problem that we have to get to better solutions.
Carolyn, we're switching over to the public company context around annual report season. As I said before, we're combing the libraries, out combing to see how people are applying, just looking for examples of how people are applying the item disclosure requirements around governance. Would you just speak a little bit categorically to how you see, your responsibility as an agency and what, is there a minimum expected approach? The board must be involved. That seems to be obviously pretty clear from the rule, but just speak a little bit to the governance section of what you're looking for in the annual reports, or specific to cyber.
Sure. Well, first of all, Latham's library sounds incredibly impressive. So kudos to you guys. First of all, and second of all, as a lawyer, we don't like to speak categorically, and I think this goes back to some of the discussion, including Jennifer, that you were having, kind of. I know that was about materiality, but a similar concept, and that is that this is not a check the box exercise, and it shouldn't be, and that's why, and I can understand the frustrations around it, but that's why there isn't a set list and set of things that each company must do, because each company is different, and we want them thinking about their specific risks and how their governance is set up and how those come together. Going to some of the points that Harriet and Melissa have made as well. So when it comes to governance, though, I agree very much with what my fellow panelists have said. This is incredibly important to make sure that there is attention to those risks and to what is being done within the company, both to try to identify and prevent incidents, but also how to respond to them. And so I'll just use a quick example, of how this can manifest. Going back several years to the Yahoo cybersecurity breach, and that's a situation where Yahoo had its, what it itself referred to as its crown jewels, usernames, passwords, email accounts of hundreds of millions of its users. The most important thing that Yahoo does, and it experienced a breach, accessing and stealing, all of this information that Yahoo knew about, including its senior managers, for 2 years before it was disclosed. So senior management knows about it. But as alleged in the SEC settlement, Yahoo's outside counsel and its auditors didn't know. So that, I think, goes to the issue we've all been talking about with governance, with boards, that when there's something major that happens like that, you want to make sure that the people in charge of governance for the company have a say and an understanding of what's happened, because that's their area of responsibility in terms of what the company says as a result, the decision about whether to say something and how. And so I think that Yahoo's kind of the quintessential example of the need to make sure that things really are escalated all the way up.
I'd like the, no checklist, and, there is obviously good guidance too in the Federal Register notices about, how you might frame the discussion in the annual reports. And Harriet, you spoke, and your agencies acted thoughtfully in trying to recognize there is no one size fits all for regulation, that in terms of the burden and just the sense of it, like not, for every size does, matter. How has your agency, in the new rules, tailored expectations for risk management from business to, business? Where's there, is there tailoring in there much, or?
I think it's inherent in how the reg is written already and how it's being implemented. And when the department conducts examinations, as happens, exam of banks or examinations of insurance entities, those are, our examiners are trained, they're specialized. We're hiring more, by the way, if anybody would like to submit a resume. Our team goes in and looks at, has there been a risk assessment done? One of the changes in the amended rule is now requiring not only a risk assessment, cyber risk assessment, to be done on a regular basis, but now annually reviewed and updated if necessary, or conducted again if there's a significant change in the profile of the entity. So looking at the risk assessment in the context of what's your business, what's your exposure, have you thought about it, have you escalated, involved the right people? That is I don't want to say it's a case by case, but it's really deferential to whatever the company's circumstances are. But, I think it's one of those where if you see that a company has averted its eyes from something and not assessed risk or not had the right processes in place, that's where you cry foul. Oh, that's not right. But other than that, I think that's a very differential risk-based approach.
Let me move on to some of the reporting requirements. And while I've got you, Harriet, I think it's going to be very interesting to see what you get in your catbird seat of everybody telling you if an extortion payment, was made. Can you just, tell us a little bit, more about that? And is there any, tips or guidance, anything you can add for companies that need
These
to
are
deal
early
with that?
days. I mean, it's early days, right? So actually, I got a similar request from another from an organization, and I think it's early days, and we'll see. And I think it's interesting in the context that's happening nationally with the Department of Homeland Security's cybersecurity agency, CISA. I think it's expected in, what is it, Melissa, next couple of years to have a regulation implemented that takes the requirements of a national, federal law, CERCIA, and requires notice of incidents from cybersecurity infrastructure entities. I think it'll be interesting to see what happens nationally with these sorts of things. But in terms of our experience so far, we're looking forward to seeing what comes in. And I think, as I said, though, the motivation for that change in the regulation was really to require organizations to give additional thought and document that they had spent some additional thought and brought in the right stakeholders when making the decision to pay a ransom payment, making sure that the stakeholders were involved. And so the design of it is inherent, the impact is inherent in the design, and then the additional insights that the department will gain from seeing what comes in, I think will be helpful, again, just as all the data is helpful.
It'd be interesting to see how people articulate the reasons payment was necessary, because there's certainly lots of advisors out there in the space that would tell you your time to recovery is something that you can discern, and it's between paying and not paying is not like, paying may not be materially quicker or materially better. It may have, other things. So I think that's the speed bump part
You and
of
I
it,
have been in
yeah?
this area a long time.
Yeah.
So I think over the last several years, I have seen a change in how the FBI and others assess the efficacy of paying ransom as the actors proliferate, their MOs change, and so paying a ransom now is no longer, as lawyers, you can't argue effectively anymore, I don't think, that the payment of the ransom mitigated significantly the risk to the data or the institution. So I think the efficacy, the narrative that could have been constructed when paying ransom is now no longer as robust as it was, and that's because the world moves on. You learn, and the facts emerge, and things change. So I hope that fewer and fewer organizations end up paying these unfortunate payments, but that's where we are.
I wonder, Carolyn, on the 8K materiality, reporting of material events. I wonder if you could. We have maybe 5-10 minutes left, and I certainly don't. I want to give you a large pocket to, comment on, as you can, on what you're seeing, what you're thinking, what you're hoping, or what you'd like to say on behalf of the SEC for the new 8K. We're monitoring those, and there's the market's reacting in a lot of different ways, incident by incident. So please share your thoughts there.
Yeah, and I, appreciate the discussion that you had about materiality earlier, and I thought it was, really great to make the point that it's not just quantitative materiality that the SEC looks at. And again, this is not unique to the cybersecurity area, and it goes back quite a long time. I think Melissa talked about, guidance from the SEC coming from 2011. There was a commission guidance from 2018 on cybersecurity that talked a lot about materiality in there as well. And making this point that, you may have a disclosure obligation, something may be material, even if you either can't quantify what it means to your bottom line, or you don't necessarily have something that rises to something that's going to really hit your revenues. But as you were talking about, Jennifer, it could be a huge reputational hit. It could have a big impact on your customer relationships or your vendor relationships. So that qualitative materiality, that could be something that's really important to investors. And so I think, I'm interested going forward in how are companies assessing that and looking at that. Are they recognizing where they've got those risks? I tend to think they should be, because I think that, companies are already focused on cybersecurity, as they should be, for business reasons. And so then is that translating into, that next step of disclosing those incidents to investors on those 8Ks, on those 6Ks?
Thank you for that. Is there any question in the room that anyone would like to ask before we wrap up? Yes, in the back there's a mic, I know.
Based on what all you guys are saying, is the federal government moving fast enough? I mean, CERCIA was passed in 2021, 2022. It's 2024 now. There's still not those reporting requirements. Do we need to be doing more faster?
Okay, everybody's looking at me. The problem is getting, I would say, significantly worse on a daily basis. And in aggregate, I don't think that the public are truly aware of how bad the problem is. We're experiencing it in pieces. I can't take the train. My kid can't go to school. My hospital's closed and things like that. And I think it's the government's responsibility and media. I think media is doing a bad job also. I think we need to say, what is the problem? Like so what? And the now what do we got to do about it? And the now what do we got to do about it hasn't been framed in this is really bad and it's getting worse. And the so what is because, you had 400 hospitals down, you got 5,000 schools down, you've got these municipalities being ransomed and these things. And this is what I want you to do about it. Well, we're doing it through New York DFS, Safety and Sound List. We're doing through SEC. We're through the FTC. We've got piecemeal approach with not national resolve that there is a real national problem of our digital vulnerability or fragility as a country and as a company, as a school, as a city, et cetera. And I think, we as Americans, I'll speak as an American, we're really good at innovation and solving problems. We just got to know what problem we're trying to solve. And if we can start to frame it in that kind of a national conversation, everybody can do something about it. And that, I think that would go a very long way. No, we're not moving fast enough.
I think on like some of the challenges, they're very significant, right? So the DHS has someone, okay, we need to have a unified reporting for, that's our vision, right? We'll have a unified portal that the federal government will sponsor for that will be consistent, whether you're HHS regulated hospital or your DOD, and Defense Industrial or whatever. You're all going to report, and you're going to have this centralized forum. Check. They're big groups of people, led by a really terrific person, right, at DHS, working really, really hard to solve something that is an IT challenge. It's an interagency challenge. It's not easy to take our patchwork of largely industry-focused vertical, regulatory, and make it into something that is highly integrated and strategic to meet the information demands of an economic and national, security. So I do believe in government in the sense that there are good people working, hard behind the, scenes, but just an extraordinary amount of effort was put between multiple stakeholders and the SEC being able to kind of refine what would it mean to get a national security pause for 30 days or whatever on the 4-day time framing of reporting. Like, it takes people in government convening and getting together. And so I too am like, oh my God, 2 years, that's so long, and you don't see it. But it doesn't mean that there isn't a lot of activity. And I think some of the challenges they go to like, how fast can new laws get passed? Not fast, not well, So there's a number of reasons fundamentally. So
There's also a lot happening at the state level and
Yeah.
in partnership.
Yeah, that's-
Our system of government, state, federal partnerships, state to state. The DFS model was adopted by 22 other states. The National Association of Insurance Commissioners adopted a model law that has been adopted by 22 other states. It's based on DFS's approach. So there's been a proliferation of more regulatory approaches across states in the sector, and then also New York continues to focus under Governor Hochul's leadership, under Superintendent Harris's, Superintendent of the Department of Financial Services, continued emphasis, and Governor Hochul recently announced proposed cybersecurity regulations for hospitals in recognition of this issue. The governor's budget and State of the State address included an emphasis on additional funding and resources to help municipalities, local governments with some foundational protection capabilities. So there's activity on multiple levels, and it has to continue happening that way because there's some purely operational things that only will happen at the local level.
it's a great point. Go ahead.
So good morning. Thank you for everything so far. Pulling the thread a little bit on governance and the stronger requirements coming out of all the new regulation. In my experience, many companies, governance is about 80% attitude and culture and 20% documentation, right? So it's about everyone thinking collectively at the company about risk and about the need to control that risk and govern appropriately. For industries that historically haven't had such strenuous regulations and maybe don't think that way first as they should, do you have one or two top tricks for helping change that culture in the company or making effective change across the board with respect to governance before there's a fine and an incident? Often our cybersecurity worlds obviously are focused on it. How do we get that message out beyond effectively, do you think?
I'll say one thing that I find is that all companies are on a journey to, becoming profitable, growing, expanding, whatever, wherever they are in their journey, they need access to other people's money, and they need access to, maybe they want to be appealing for a strategic, M&A or whatever it is. And so diligence happens everywhere, not just straight up, are you in compliance? Like if you're a public company or if you're subject to DFS, then do those rules. And if you're not in compliance, that's straightforward. But these controls points around cyber, I just see them in our practice as people want to access I call it other people's money through, capital markets or financing or whatever they want. Others are asking, them to do that. And so I just leverage that and say, if you want to grow, you need to have this documented. We have to turn it over. So we just always leverage, like, if you want to get access, you want to go through your next financing round, you're at a Series A, you want a Series C, you want, wherever they are in their journey, somebody else wants them to have the documented program besides their consultant, so.
What an amazing discussion. I thank you so much, and thank you, Carolyn, for joining us remotely. If you can join me in thanking the Meg Thank you. Thank you.